Good morning, everyone. Welcome to today's webinar, Uses and Benefits of the Article 81 Guardianship Proceedings. My name is Kathy Purdy, and I will be your host for today's presentation. We are anticipating a 50 to 55-minute presentation with 5 to 10-minute questions at the end. You may use the chat box in the GoToWebinar sidebar on the right-hand side of your screen to submit questions throughout the webinar. It is now my pleasure to introduce to you today's speakers, Mark Mainello and John McKay. Mark is a long-term care attorney with 15 years experience representing nursing homes in guardianship matters, administrative affairs, hearings, civil litigation, and appeals. Mark has an additional 9 years of experience in real estate, trust, and estate practice litigation, and surrogate court presentation. Mark offers extensive experience in the litigation of complex civil, commercial, corporate, municipal, and estate law issues. Our other speaker, John McKay, is a litigation attorney who began his practice in 1985 as an assistant district attorney for Nassau County and has 28 years of experience in all aspects of litigation and an in-depth knowledge of litigation support for long-term care providers and contracts, commercial matters, employment, guardianship, medical malpractice, personal injury, and civil rights issues. Good morning, gentlemen.
Thank you, Kathy.
Thank you, Kathy.
Well, this is John McKay, and I'll begin our presentation today and just telling you a little bit about myself very quickly. First of all, thank you for that lovely introduction, Kathy. I appreciate that. As you may see from our presenter's screen, that I am a member of Bond, Shennick & King's Long-Term Health Care Department and the Litigation Department. As Kathy told you, I have approximately 28 years of litigation experience, and that involves trying cases throughout the 5 boroughs of New York and also in various other jurisdictions throughout the state. On its appellate level, I've done appeals, and I've also worked outside the state on a host of different matters. I regularly, in this today, appear before the judiciary in the 5 boroughs of the city of New York and also out in Long Island in Nassau and Suffolk County. I practice in the Garden City office, and I enjoy the litigation process extremely much, but mostly I involve myself today with doing many guardianship matters for our various institutions that we represent throughout the state of New York. And I do so with my very longtime partner, Mark Mainello. Mark?
Thank you, John, and thank you again, Kathy, for that nice introduction. Just very briefly about my background. I am a member of the Bond firm out of the Albany Regional Office. My practice area is the healthcare and long-term care practice group. I've been practicing law for approximately 25 years, and for the past 15 years, almost exclusively in the healthcare, long-term care areas. Out of our office, we represent nursing home clients, hospitals, and related healthcare facilities, not only from a general practice standpoint, but also from special practice and special litigation. In addition to guardianships, I also deal with a fair amount of construction contract review, supplier and vendor contract review for various facilities and institutions, corporate compliance matters. We deal a lot with HIPAA and medical records issues, as well as CON and support services in the CON process. I also get involved with real property transactions involving facilities, project financing, and litigation as well. A fair amount of my litigation practice, in addition to the guardianship work, is primarily in the Article 78 area, which deals with commencing actions and proceedings involving the state and municipal governments. As part of the litigation, we also get involved with assisting clients and facilities with reviewing their admissions agreements, their private pay and NAMI agreements, and working with them on collection and other matters for recovering receivables and whatnot. In addition, we also get involved quite a bit in the area of the guardianship law, primarily under Article 81, which we're going to be talking about extensively this morning. Also, we get involved in some respects with Article 17A guardianships, which is a special area. Briefly about myself, I've been involved in the guardianship area since the enactment of the statute we're about to talk about today, Article 81, which occurred back in April of 1993. And where I got involved with it was I took a course and became certified to act as a court evaluator and a appointed counsel for an alleged incapacitated person, and also as a guardian. And you'll be hearing more about those terms as we get into the presentation this morning. And you'll hear more of those terms and the anachronisms from John. John is going to explain the AIP and various terms that you're going to hear throughout this seminar dealing with the guardianship process.
Thanks, Mark. Now, the title of our presentation, as you all know, is the uses and benefits of the Article 81 guardianship proceeding. Now, without being able to know the background of the statute itself or the process, you can never really appreciate it, the use and benefits of the Article 81 guardianship proceeding to the various assisted care living facilities and nursing homes throughout our state. So here, I'm going to go through slowly here the overview of what the guardianship process is all about. First of all, everyone should understand that the guardianship process is an adversarial proceeding. And what I mean by that is that it's brought on by a petition and a notice of petition, which requires the petitioner, and often that can be either a family member, a friend, or sometimes it can be the institution in which the individual resides in, on behalf of the prospective AIP, which is the alleged incapacitated person. And it's being brought for their benefit, to secure its assets, to secure their persons safely, so that they do not have any harm done to them, both physically or financially. So the statute itself is called, under the mental hygiene law, Article 81. And it often is done to relieve an individual of its burdens. It is attempted to create a viable legal entity for which people can utilize for the benefit of the person. The guardian does this for its ward. It creates structure, and it preserves the assets and the physical status of the person so that no harm comes to the individual. In the case of something where there is immediate need to do something, where there's a danger physically to the individual, or there may be a danger of a loss of assets and financial wherewithal of the person, the guardianship process contemplates a temporary guardian to be put in place immediately upon the filing of a petition in order to effectuate some specific and some direct need that can be articulated by the process and by the paperwork put before the court. So, Mark, why don't you tell us, there was a history to the guardianship process that came before Article 81 in the 1990s, and maybe you could tell the audience what that was.
That's correct, John. Article 81 came about in 1993, and what some of you might be aware of is that the former terms were known in New York as conservators and committees, and they were under Article 77 and Article 78 of the mental hygiene law. And it was determined because those particular types of appointments dealt with the basic phrase back in the day prior to 1993 was incompetency, legal incompetency, and that really what that came down to was looking at a medical condition or some type of a condition of the individual, whether it was mental retardation or alcohol abuse, and that they were deemed to be incompetent. And as a result of that, a committee could be appointed for them, or a conservator. A conservator was limited to pretty much just dealing with the person's property, real and personal. The committee, however, dealt more specifically with the overall person, personal issues as well as property issues. But the bottom line here is to get to that point, you had to go through a court proceeding and demonstrate to the court that you were dealing with someone who was deemed incompetent. And that presented a whole host of issues, because now you're in for a dime, you're in for a dollar. Basically, once you're incompetent, you've taken over that person's life in total as a committee or as a conservator. There was no, as John mentioned, no temporary guardian or limited guardian to do certain limited things. So the statute really did not work. It was not workable. There was very little flexibility, and the courts tried to make it more flexible, and ultimately our state's highest court, Court of Appeals, determined that courts were getting too flexible with it and basically set it up to the legislature to fix things, and that is to come up with a solution to allow for fiduciaries to make decisions without having to make all decisions for everyone. And that's where Article 81 of the mental hygiene law came into vogue. The statute itself It's been here since 1993. It's here. It's going to be here for a long time. There have been tweaks along the way over the past 20 years. There's also been discussions about making additional modifications. John's going to talk about it briefly later on. There's been a recent enactment to allow for the recognition of foreign state guardians. We're not going to get into too deep, but I'll mention it. But the idea here is that there's a future here, and it's going to be around. And it's going to be even more pertinent now as we get into and embark upon managed long-term care, which is going to be mandatory in New York, as most of you are aware of and know. And of course, in April of next year, we'll be dealing with FIDA. And in that regard, we're going to be dealing with individuals, residents, patients, who are going to have to make decisions about plans, and plans are going to have to make decisions about residents. And they may not have the capacity. And that's going to be the concept today we're talking about, not competency, but capacity of the individual to make reasonable decisions about enrollment, disenrollment, filing grievances, and therefore the process of guardianship might take on a whole other meaning with aiding and advocating these residents who are in need.
Now, as I stated before, as we talked about the uses and benefits of the guardianship proceeding, you must have to, before even doing that, understand that if the goal is to get a guardian, what is the legal standard that the court uses in order to establish a guardianship? In this case, since the law has changed in that regard, from going from incompetency to incapacity, there's a difference in the way in which the court looks at the prospective, what they call the alleged incapacitated person. They look at what are their greatest functional abilities, not their limitations, but their abilities. That's because the new standard is a standard of establishing a guardian for the person with the least restrictive methods possible in order to allow a person the greatest amount of autonomy. The thought being is that as much as people can, they should do for themselves. We don't want people who don't need their property managed to have someone manage their property. And on the same hand, we don't want people who can manage their persons but not their property, have people managing where they live or what they do with their persons physically. So the standard is make sure that we establish a guardianship if it's necessary with the least restrictive methods. And the standard for establishing a guardian in the first place is, does the individual recognize whether or not they need a guardian for themselves and for being able to do the things that they need to do financially and physically? Do they recognize that their harm and danger could come to them if they did not handle these issues on their own? And therefore the court takes that, makes sure that there's no harm going to be done, establish a guardianship with the least restrictive methods possible in order to prepare for the welfare and the financial and physical welfare of the individual. Mark, why don't we try to go through and address some of the issues that we might do and get involved in investigation before we actually even begin the process of seeking the petition and the guardianship process.
Thank you, John. Just a minute, before we get to that investigation, I just want to make mention of the fact that, as John mentioned, it is critical that we recognize the legal standard, because these guardianship proceedings, the focus has to be on the resident, the need of the patient. We're looking for their welfare and their safety and their security, to have a fiduciary appointed to make sure they're getting what they need. And so how does that relate to the facility and the hospital, so to speak? Well, benefiting the resident can benefit the facility and the hospital. And what I'm talking about specifically is generally what we see, the situation perhaps where you have a resident who is no longer paying their bill. They've run out of funds. And a family member or whoever may have signed them into the facility for whatever reason is not being responsive or reactive to the facility or the institution to basically do what they need to do, and that is to start the process for applying for Medicaid. So by virtue of having a guardian appointed, the benefit of the resident is now that they may be able to get a payer source and be eligible for Medicaid, a benefit that they would be entitled to. And the benefit for the facility obviously is now that they have a payer source to pay for the cost of care, because as we all know, in the event that that resident individual is not paying for the cost of care, that presents problems which jeopardize the health and welfare of the individual because of the potential for discharge. So I just wanted to make that point out there, that there's a number of events that could cause this process to be triggered. but that's one of the items I wanted to bring to your attention, the benefits of both the resident and of the facility and institution. And we'll talk about that more later. Now, in getting to that point, as John mentioned, this is a court proceeding, and oftentimes they can be contested. Sometimes they're not, but sometimes they are. So we always recommend to our clients, before we embark down the potential guardianship path, that we do a great deal of due diligence, because we look at guardianship as a last resort. It's not an initial step, it's a last resort. We look to see what else is available to help that resident, whether it may be a family member who signed the admission agreement as designated rep or a responsible party. Perhaps there's a power of attorney out there. Perhaps there's a healthcare proxy. There may be individuals who are joint title holders to bank accounts, or people who have access to their financial information. In any event, the point is that depending upon why we're looking at the process, why we may need a guardian, we have to focus in on, before we take that step, working with the family, perhaps working with the resident if they have some level of capacity, to make sure that we've done and exhausted those opportunities. And oftentimes, what we do is we ask the client to provide to us as much information as they can about the resident, the face sheet, who the contact people are. And we ask the facility to make those contacts and make sure we have phone calls and letters. And I'm not talking about one or two. I'm talking about a detailed, documented effort to try to work with individuals, family members, whoever they may be, and to make sure that we document that. And this is all in preparation for the need for the guardianship proceeding. As I say, sometimes we'll get the documentation, we'll review it, and we'll make an assessment as to whether or not we can work with that power of attorney. And we often prepare a letter or letters for the facility to write to these individuals and explain to them what may happen. And that's important down the road, as John mentions, when we get to the petition phase and the hearing phase, as evidence to demonstrate to the judge that, Judge, here's what we've tried to do, and we've gotten no reaction. Now, there are instances when we do get reactions, and that's good. We may avoid the guardianship process. However, there's also many instances when, despite our efforts, the facility's efforts, that those responses are not made.
Well, I guess then we were really talking about starting the process, and we always say start strong and then end strong. If we start strong and doing the investigative process, as Mark indicated, then the rest of the process, and hopefully all the way to the conclusion, will end strong, having a favorable result both for the institution or the family member who's the guardian, or that institution who's a nonprofit corporation that may become a guardian, and it'll ultimately alleviate burdens for all those involved. So when we begin commencing the guardianship process, we will have the necessary documents attaching to our various affirmations and affidavits. But please note that the way the matter is started is by order to show cause, and it's presented to the court for signing. And usually there are affirmations, there are affidavits sometimes, and there is a petition for guardianship. And the petition specifically must outline that you've met the legal standard in order to have a guardian put in place. And sometimes that requires, but not always, affirmations and affidavits from the facility showing that, in fact, this person requires and needs and would benefit from a guardian being put in place. Now, you'll notice that in our next slide, there are various different parties and interested persons involved in every guardianship. And one of them, who is a very vital person to the court's process, is the court evaluator. The court evaluator is a non-biased, integral arm of the court who does and performs investigation for the court in order to prepare a report which usually recommends or does not recommend guardianship. And that court evaluator goes about her job by going to the facility or where the AIP, the alleged incapacitated person, resides, and meets with them, meets with the family, speaks to all the individuals that we will have or already have spoken to, and gets an idea as to the need for the guardianship, assesses the individual. And after the assessment is made, they also check the financial status of the individual. And they do so by having the right to access financial records, because the court can give them such records access, and also to access the medical records of the individual in order to make an assessment of the individual's capacity, and also make an assessment of how much the individual can function on their own. Once again, going back to that legal standard, the least restrictive means necessary. So the next person who's very important in the process is the court-appointed attorney. Not every guardianship will have a court-appointed attorney, but often is the case that when we're indicating individuals that have limited funds and resources, the court sees the need to assign them an attorney. In New York, in the 5 boroughs, that duty has often resided with the mental hygiene legal services. And let me tell you, their position is to advocate for the independence of the individual as much as possible. Sometimes so much so that it becomes a very difficult and contested process, the whole guardianship proceeding. The next person you'll see is that we have the family involved, and then we have people who may have powers of attorney. There may be a lawyer out there that holds a power of attorney on behalf of an individual. They have to be noticed in a guardianship. The hallmark of this whole process is as much cooperation as possible, because the standard is to do the best that the group can do for the interest of the individual, recognizing that if we do the best for the individual, ultimately we'll be doing best for the resident and the facility in which they live in, and making sure that their bills get paid, and making sure that their debts are handled, and making sure all their physical needs are taken care of. So when we commence the proceeding with the order to show cause, and we deal with all these parties, if we create a unified cooperative effort, ultimately we'll be doing ourselves the best service. Mark, can you take some of the issues with regard to how, as an attorney being in a guardianship process, would put in the proof, would start the process of actually placing before the court the necessary information to actually receive an order of guardianship?
Thank you, John. One comment I wanted to make about the actual, before I get to that, I just wanted to make one point about the court evaluator. As John mentioned, the court evaluator has a statutory role and function, and I've served in that capacity many times, and John and I, in bringing proceedings on behalf of facilities, have dealt with court evaluators quite regularly. And I want to emphasize the fact that a court evaluator is appointed by the judge that will hear the case. And it's important to recognize that that court evaluator has an obligation and a responsibility to make a written report to the court, as John mentioned, a recommendation as to the need for the guardianship, and also, equally important, who that guardian should be. And I want to bear in mind here that we might want to focus in on not only the need for a guardian, but who it is that we're dealing with ultimately that may become a guardian. In fact, it could be that person who we may be having issues with. So I want to just make that one point about the court evaluator, because they can have a lot of sway with respect to the judge in connection with these particular proceedings. The court does not have to accept the recommendations, but the court will look strongly at them. I just want to bring that point up, John.
I think that's a great point, and we'll get into it a little more detailed, I think, in a future slide, Mark.
That's right. So now getting into the actual hearing itself, putting in the proof. One of the things that you have to recognize is if the court ultimately decides to appoint a guardian for an individual, that individual has lost their civil rights, their liberties. So starting off from the get-go, courts do not necessarily like to appoint a guardian if they don't have to. So it's an obligation on our part as the petitioner's counsel to demonstrate that need, as we've been talking about so far, the importance of why the guardian is needed in this particular case to help the individual. So starting from that premise, we have to make sure that we've done the due diligence. As John mentioned, we've prepared the legal papers, and now we're at the point where we're embarking upon the actual hearing itself. And what does that entail? Well, I've had guardianship hearings in over 15 counties throughout the state, and several judges, and they're not always done the same way depending upon the jurisdiction you're in. You have to recognize here that courts have very busy calendars and schedules, but the idea here is that these things do have to take an extreme fast track because of the nature of the case, the age of the individuals we're talking about, and in many cases the urgency of why these things need to be done. So from that standpoint, what we typically experience is that the court will sign the order to show cause and put a return date to appear. And that return date has to be approximately 30 days from the time that the order to show cause is submission to the judge. So that's a very short time period to get prepared for and to put in proof and testimony at the hearing. So oftentimes what we'll do is we'll contact the court in advance to find out if that date that the judge required appearances, is going to be the actual hearing date, or if that will be a conference date. And why is that important? Well, it's important because we're all busy, and we need to bring witnesses to our hearing to prove the elements that John mentioned in the petition and the legal standard. And oftentimes that entails bringing from the facility someone from nursing, someone from social work, someone from finance, typically as a minimum. And that may depend, too, depending upon whether or not we think this is going to be a truly contested proceeding or not. And oftentimes we'll get kind of a heads up by keeping in contact with the court evaluator as the process unfolds. But now that we're at the hearing, what does that mean? That means that if the judge determines on the return date we're actually going to put in proof and testimony, or at some short time thereafter, we're looking at having witnesses testify, and that's staff from the facility. We may also have perhaps a nurse, a social worker, and as I mentioned, finance, to explain why this individual needs to have a guardian appointed for them. Now, with that said, we also may encounter, because you have to remember, we have, as John mentioned, an attorney representing the AIP, and they may take the position that they have to advocate for the rights of the individual who's the subject of the proceeding, the AIP, and that AIP, even though they may not be able to tell them what their position is about the need for a guardian, they have to make sure that we meet our elements of the case and that we meet our burden. So they may object to certain testimony, and that may entail, for example, testimony from a nurse. Recognizing that under HIPAA, we can disclose certain information for various reasons, such as healthcare operations and treatment and payment. That allows us to disclose information in certain instances, perhaps even to the court evaluator, but again, we have to look at that very closely before we release information, and it's got to be the minimum amount necessary as well. And we have to make sure that there may be even a court order authorizing the court evaluator to access the information. But when we get to the hearing, the attorney for the AIP can actually object to medical testimony. Now, the point there is that under Article 81, technically, you don't need to have medical testimony because we're focusing in on the capacity, what the individual can do, what they cannot do. That's the purpose of Article 81. With that said, we do run into courts and judges on occasion that do want to hear testimony, and some judges who don't want to hear medical testimony. So they may sustain the objection. So what happens then? Well, again, in preparation for the hearings, we prepare our witnesses, the nurse, the social worker, for these types of objections. And then what we do is we allow them to testify about their direct dealings with the resident, conversations that they've had with them, how they've answered questions. Do they know where they are? Do they have the ability to review or perhaps even consider what a Medicaid application entails? And that's the type of testimony that we have to elicit from our social worker or our nurse, as well as from the financial person, where we stand financially. What is the person, what is their payment situation? We also may have testimony to add regarding information from the file about who the healthcare proxy may be, who the power of attorney is, and what has been going on with our efforts to communicate with those individuals. And this is important testimony to prove the elements of the need for a guardian, why this individual is in need of a fiduciary to make decisions for them. And John, do you have anything to add at that point, John?
Well, I think that we have to always recognize that everything that we do is always have to conform to the legal standard that's required by the court. The court's not going to want to hear any more or any less than it needs to in these matters because it wants to just assume that as long as it has enough information, it can provide for the individual. It will do so as long as we can support the legal standard. Will the individual suffer harm if this is not done? Will the individual's finances be somehow compromised? Will the individual's person be compromised in some fashion? So that's the standard by which we all operate, and that's what the hearing will always go to, with taking into that consideration. But once we, remember you said before, we're going to start strong, we're going to end strong, right, Mark?
And John, let me just add in that, because one of the things that we do encounter is preparation. We do prepare our witnesses extensively for the hearing because they may be subject to cross-examination. And I know that we've had situations where our witnesses get very nervous about that, and we take great pains to go through that process and anticipate what questions they might be asked on cross-examination, whether it's from the court evaluator who maybe feels that the guardian is not necessary, or more importantly, they feel that the person who we want to be the guardian shouldn't be the guardian. So we prepare our witnesses both for our direct proof, and we also prepare for what we anticipate may be questions and cross-examination from the court evaluators, perhaps also by mental hygienists representing the AIP or a private attorney.
So in effect, prior to even starting this proceeding, Mark, we already are taking into consideration, are we not, who will be the guardian? We already have an idea because we've discussed this with the social service department of the institution. We've discussed with the family. And often we get back information like the family may not be up to it. They may not feel that they have the wherewithal or the time that it takes in order to handle these things. But we, as the attorneys for the petitioners, always are considering who's going to be the guardian. And why do we do that? We do that specifically so that when we do have a guardian put in place, we have a person who's going to be responsive to the needs of both the individual and the residents and the facility in which the resident is residing. And that's very important. So we also have to decide, well, who can be a guardian? Often, in the middle of a hearing, Mark will tell you that someone will stand up and say, I'm his uncle, and I want to be able to be the person's guardian. We may not have heard anything from this person for the last 5 years. And suddenly, we're dealing with an individual out of the blue who wants to be guardian. We may have another individual in mind. Or we may have a thought that a non-biased third-party, not-for-profit corporation should become the guardian because we have recognized that there may be problems with some allegations of financial transactions that may not be proper prior to the whole proceeding and may have been the reason why we brought the proceeding in the first place, Mark. So prior to this whole process starting, our office always considers who we want to be the guardian. But remember, in New York, there are certain standards of who can be guardian. You have to be 18 years old if you're an individual. Now, it's not part of the law, Mark, but in many different parts of the state, they have court rules. And in New York City, they have court rules. And one of the court rules in Manhattan says that if you're a felon, someone who has been convicted of a felony, you cannot be a guardian. But that's not what Article 81 says. But we do know that in some courts say that you can't be if you've been convicted of a felony. Now, it sounds like it's rather rote, but in fact, it's an issue at times. And I've had it come up at times because the person's felony dealt with a long time ago and had nothing to do with fraud or deceit or anything, and why shouldn't they be able to be the guardian of their grandmother or their mother? So there are issues out there. Remember, too, is attorneys sometimes can be guardians. Also, and sometimes less responsive, are these guardianship service organizations. The reason why they're less responsive, sometimes they have hundreds of different wards out there they have to take care of, and they just can't meet the needs of the financial institutions. So remember, in this case, you have to consider, who you want to be the guardian before you bring this. And remember, there can be no conflicts between the parties. And what do I mean by conflicts? Well, the institution itself can't put its financial department representative as the guardian. Obviously a conflict there, Mark, as you know. There are other conflicts that also exist. It can't be a creditor. Sometimes in the past, creditors wanted to become guardians in order to make sure that they got paid. That is improper also, and the court won't allow a creditor to be a guardian. And also a provider, just someone who is providing the medical care. As you can see, there may a conflict arise when someone takes that position vis-a-vis their ward, because whose interest are they going to serve? Once again, it gets back to the best interest of the alleged incapacitated person. So Mark, why don't you tell us some of the critical impacts of guardianship and the importance of the person who may be appointed and how they are managed in the process vis-a-vis the facilities and how we work with them.
Thank you, John. As John mentioned, in these guardianship cases, it's important to recognize that it can be bifurcated. The need for the guardian may be stipulated to, it may be agreed to. There may not be an issue in that regard. But who ultimately becomes the guardian could be an issue of litigation, and qualification is a very big part of that. As John mentioned, there may be someone that we might be advocating, or if we're not advocating someone, we want to make sure someone who is being considered is able to do what is necessary to serve the best interests of the AIP. And that's another thing that we want to recognize too, is once the guardianship proceeding has concluded, hopefully in the appointment of a guardian, that's the expectation, then the individual is then referred to, instead of the alleged incapacitated person, as the incapacitated person. So and that's the short form for that is IP. But what we're talking about here is when we're at the point now where the court has made a determination that a guardian should be appointed and who that guardian should be. And by the way, I should add, oftentimes outside of the New York City area, we oftentimes notify the local commissioner of social services as a potential guardian. And they are actually listed as a potential guardian in certain jurisdictions. As John mentioned, it's difficult for the facility or the institution because of potential conflicts. And we've encountered situations where the Commissioner of Social Services, they're very busy, their adult protective unit is very busy. They will sometimes resist the appointment of the guardian. And sometimes what they'll do, which we have to be very careful of, they'll actually find a family member, and I hate to use the term, but prop them up and make them look like a queen for the day. This is the very person that we may have had difficulties with dealing with all along, whether it's the healthcare agent or the proxy or the power of attorney. And for whatever reason, now all of a sudden, the DSS people are coming in and say, oh, Judge, we have a person right here who's willing to serve. And now we've got to deal with, explain to the judge why that person was a problem. Again, these are all the things that pop up during the course of the proceeding, and that's why it's so important, as John mentioned, to focus in on making sure we have the right person to be appointed guardian. And why is that? Because the guardian is a fiduciary. Under the law, once you're appointed as guardian, you have an obligation and a responsibility to look out for the welfare and benefit of the resident, of the individual. And oftentimes it's our job to make sure that that guardian is doing their job. And what do I mean by that? Well, as I mentioned earlier, judges typically don't like to appoint guardians if they don't have to. But if they do, oftentimes we've encountered that they like to defer to a family member if there's one that can be around, or one that can be available. And in our situation, we want to make sure that that family member is doing the right thing. And oftentimes they don't have the money or the resources to pay for a lawyer to help them. So our job is not finished. Oftentimes, I like to say, John and I talk about the fact that we've gone through the guardianship process, but now the real work begins. We're at a point now where the court has appointed a guardian, perhaps a family member, and they're kind of out there and they don't really know what to do. What's the next step? I mean, there's an obligation actually once the court issues an order in judgment, which details what the powers of the guardian will be, and that's important because that's what the guardian has, as specified in the order in judgment, the powers. What's not specified, that guardian does not have that power, and that remains in the hands of the resident. So we have to make sure that that order and judgment is prepared properly. We, as the petitioner, typically will prepare the order and judgment, will submit it among counsel who's involved in the proceeding, and make sure that the powers that are in there are appropriate and necessary for the individual. But now we have to make sure that it's implemented. And oftentimes you have to work with that family member. Sometimes it's an attorney. It's an attorney that may be not knowledgeable in the areas of Medicaid or fair hearings, and we have to work with them on those issues as well. So again, it's important that we work with them. We make sure they locate and identify assets, locate and identify income. There may be issues with securing NAMI. There may be issues with applying for benefits, becoming a responsible party, representative payee for Social Security. And it's important that we work with them and make sure that they're not left alone, because oftentimes what will happen is nothing will get done. So the work starts as well there. And as John mentioned, we start strong, we finish strong, and we continue to work throughout this process to get what the patient, the resident needs.
Mark, how many times have you come across it? Your facility comes to you and they say, I know you didn't bring the petition, Mark, but you know, we had this one fellow who brought the petition as attorney, and now he's not doing anything.
That's a good point, John. That happens more often than you think. We'll get a call from a client in a facility, and they'll say, we used this local attorney to bring the guardianship proceeding on. And sometimes you get into these guardianship proceedings and you find that the issue is not contested in the form of the need for the guardian, and maybe even not the guardian themselves. But that attorney then all of a sudden says, I've done my job, and they're not reactive to the client anymore, and the guardian is just sitting there. They don't know what to do. They might not even gotten their commission, and that's another thing. Technically, after the order of judgment signed, they're supposed to get a commission, maybe file a bond. There are steps that have to be taken that the guardian needs to do. They're a fiduciary. They also have to visit with the individual 4 times a year as a minimum. They have to file annual and initial reports. There is a work there. There's a process that has to be done, And oftentimes these individuals who are not represented by counsel, or if the facility may have counsel that sits on the front end, the work still needs to continue. And oftentimes we encounter that, especially in the Medicaid area, where you're dealing with fair hearings that may be beyond certain levels of competency for attorneys, and we have to make sure that that whole process is planned out from start to finish.
Right. You get into situations and you're asked to come in and you say, hey, listen, now we have the guardianship, but you know that Medicaid had denied the resident benefits already. What can you do, Mr. McKay? Well, often the case is that we come in and we'll assist the guardian to apply for a fair hearing, and then we'll go with the guardian to the fair hearing and help them present their proof as why they should have their Medicaid benefits restored. Often, while it seems like it's not a big deal, it can be a hyper-technical area in which they're not used to practicing in. If it is an attorney or if it's a family member, they have no idea, and they're left to the whims and the vagaries of that process, and the ALJs, the administrative law judges, who sit there, and often they're not very attentive to the needs of the guardians and their wards. So you really have to come in there and understand the process in order to help all the parties. Here, what we're trying to do is hopefully benefit the individual by identifying a payer source, and so that this individual will be not left without their benefits to pay that, because often it is the case is that places them at risk, Mark, for discharge, and we can never have that happen. Our efforts are always for the benefit of the individual, even to the extent of making sure that we can identify the source of funding and resources so that they can retain their position at the facilities, that they can maintain their medical benefits. It's very important, and we do this all the time with the various guardians that we work with, but it can become a very difficult and painful process for the institutions dealing with these people. And remember, in all times that when we're dealing with these guardians are not just taking care of finances, they're taking care of their personal needs, their cultural needs, their religious needs. It is a big undertaking to be a guardian, and some of these not-for-profit institutions really can't handle all the various issues that crop up in these guardianship cases. And what I always tell them is look at all the powers that you've been given. Are you fulfilling those requirements? And when you start reading how many there are, you realize, wow, so many of these things are just going by the wayside, Mark, and not being handled correctly, and ultimately will be to the detriment of the individual, and then, of course, it'll be a detriment to our clients, the facilities where they reside. So it's very important. Let's talk a little bit about why the guardianship process is helpful. Remember, we keep on stressing it's to protect the resident, to protect his assets, his person. It creates an entity in the guardian to whom we can address issues with. And hopefully this person, or this, I guess, institution, if you will, is going to be responsive. Remember, what are the other ideas? Well, it helps to place individuals in the position of being able to locate assets. There's actually a proceeding, Mark, we just discussed this morning, about a proceeding within the proceeding to allow the guardian to go out and locate assets, and they have the right to subpoena power to go out and have that. Also, it allows us to assist guardians to marshal those assets and to restore the assets. And when we restore them, many times we come into a guardianship situation where we see the courts in their decision and order has said, hey, listen, the grandson or the nephew has actually taken funds illegally from the AIP, or in this case now the IP, and those funds need to be restored. Well, there needs to be a process, but if you go back to the guardianship order, sometimes in there the judge is telling the guardian what to do. They just don't even realize how to get to that next step. And it's our duty, it's our obligation to best that we can, and often we are also thwarted in our efforts, is to go out and assist that. So, Mark, tell us why you think some of the other issues and how and why a guardianship is helpful for the individual and the institution.
Right. The first thing I want to state is that, and this is a very important part that has to be recognized, guardianship is not a collection device. We have to recognize that. Courts do not like to appoint guardians. I've said that a couple times, and they don't like to look look out for the benefits of anybody else but the subject of the proceeding. It's all about the alleged incapacitated person. So courts are not there for the benefit of the nursing home, the hospital, a spouse, a child. They're there to see whether or not this individual, make a determination that this individual truly needs to have a guardian and why. And as John mentioned, there are a variety of reasons of why. And it breaks down to personal needs and or property decision making, fiscal management. And as we've just talked about some of those reasons, they delve into both. But, and we can have a guardian of the person and a guardian of the property, or we can have a guardian for both. They can be two hats in one. Again, it all depends upon what the ultimate order provides for in terms of the powers. But what we want to recognize here is that this guardianship, that this role is very important. And by helping the guardian, we are also able to help the resident and help the facility as well. So it's all kind of in tandem with each other. But when we get to court, we have to recognize that we are there for the benefit of the individual. We're not there to seek payment for the nursing home. As an offshoot, what we're doing is trying to get that resident what they're entitled to, whether it may be a recovery of assets that were transferred improperly, whether it was fiscal management, their income is not being collected. All these things put them at risk. They put them at risk, and these are problems that need to be addressed, and that's the purpose of the guardianship role and function. As John mentioned, there's also personal decision-making, which kind of offshoots into perhaps healthcare decision-making. With the enactment of the Family Healthcare Decisions Act, we have found a reduced need to have guardians appointed for making medical decision-making, but that doesn't mean that the guardian cannot be appointed for that purpose either. And we're also talking about not only dealing with personal decision-making, but also perhaps making decisions of who visits the individual. We've had cases where we've had disputes with family members that come in, and they don't get along for whatever reason. And there's no one to say, you come in now, you come in later. That guardian can be the person that makes decisions about where that person's going to reside, who that person's going to be visited by, and when. It's, in essence, almost like a parent in that regard. So we have to make sure that we recognize that this guardian has an extensive amount of responsibility, but also a significant amount of power. And we have to make sure that power is used in the right way for the benefit of the individual who's the subject of the proceeding. So, in essence, what we want to do, though, is make sure that the resident is being best served by their guardian, and hopefully what they're doing is doing things to protect that resident. So, for example, if the issue is not having a payer source and subjecting the resident to potential discharge because of that, and that could be by virtue of the admission agreement, which says expressly, that you could be subject to discharge if your bill's not being paid, or by regulation. Now we've got a guardian in place, and they can hopefully redress and correct a situation that put that individual in potential harm or peril to begin with. So we may have to work with that individual to get a payer source, to apply for benefits. As John mentioned, I've had cases where guardians have been appointed by a judge off a list, and it's an attorney. They wouldn't know what a fair hearing was if their life depended on it. Yeah. And they wouldn't understand what Medicaid is, or very limited knowledge. So these are the types of things that we have to make sure we work with through the facility and through the guardian, and perhaps even the guardian's attorney if they happen to have one. We have to recognize, too, that there is a cost-benefit analysis to this situation. These proceedings are litigation, and there's a cost associated to it. So we want to make sure that we're looking at what's involved with the cost associated with these proceedings. If the situation is such that, maybe 1 month of NAMI has not been paid, if it's going to cost $4,000 or $5,000 to bring a guardianship proceeding for an $800 NAMI contribution, you've got to look at that. I mean, it doesn't make sense. There's an economics as well. So we have to take into account the whole picture. If there's much more to it than what's needed for that, then yes. But if it's just limited to that one issue, again, it's not a collection device. We cannot emphasize that enough. Right. And the time frames are critical. I can't say enough, John, and you've seen this too. We'll get a call from a client, and they'll send us a report or file, and we'll see that the bill hasn't been paid, and it's over $120,000. It's been a year. And the first question that we ask is, what's been going on? Why has it gotten so big? And I know people are busy, but that's the first question the court evaluator is going to ask. That's the first question the judge is going to ask. What has been going on? Hopefully we'll be saying that the facility has been working with the resident's family to try to get through this process. But sometimes we don't get that answer. And it's an important thing that has to be focused on. Time frames are critical. Remember now, when a person applies for Medicaid, you've got a 3-month retro period. So even if you get a guardian appointed to apply for Medicaid, you may be well beyond the 3-month window.
Mark, just one of the things that I wanted to make sure everyone understood out there, upon the filing of the guardianship, Isn't it true that Medicaid will kick in and to 3 months prior to that if this person would be allegedly someone who would benefit from Medicaid payments? Is that correct?
John, that's a great point. We have had a fair amount of success in commencing guardianship cases. The typical situation, as we talked about, is where the individual has run out of funds, we're not getting anything from the power of attorney or the family, and we believe that a Medicaid application should be filed. We have had a fair amount of success where we've actually applied, we have filed the guardianship petition, and by virtue of doing that, we have alerted the local DSS office or HRA,
correct,
and they will put the individual on Medicaid retroactive to 3 months from the date of the actual petition filing. So in essence, it kind of acts like a temporary Medicaid application with a temporary benefit. Now, what have we done by virtue of that? We have, in essence, have allowed a payer source to continue only during the course of the guardianship proceeding, because once the guardianship proceeding is resolved with the appointment of the guardian, at that point, the judge says, okay, now you've got an individual here who can do the things that are necessary to get the true Medicaid application submitted.
Right.
Getting all the bank statements, getting the an idea of what the assets are, things of that nature, John. So yes, that's an important point that we have to recognize as part of this process.
Well, we've talked a lot about the triggering events of guardianship. We've talked about working with the guardian. We often have to come to the final conclusion and ask ourselves, well, why do we want to proceed with guardianship? And often I say to people is that it is a process which ultimately can resolve problems, whether it relieves the individual of the burdens that they were under and places them with a guardian, and the facility now can have a responsive individual or a responsive institution to take care of these things. The individual is relieved of these burdens, and that's the primary and most important thing the court wants to always take into consideration. Has it done the right thing by the ward, the individual? But for us, as lawyers, it creates structure. It allows us to finally have someone that we can talk to, someone that we can go to. But often, and Mark, you'll tell me more times than not, we have just as many problems sometimes with our guardians and the institutions that are allegedly in place to represent these wards as we do the individuals themselves. And it's very difficult. But at least now we have a way in which we can touch these people. Now, the only problem with that is sometimes as these yearly annual reports and accountings that they are required, some of our courts down in New York City are not as mandatory about the filing those reports on a timely basis. And therefore, it creates a backlog of what really is going on with this individual and their payments and who's to blame and who is to actually marshal those assets. And it becomes difficult, once again, putting the burden back upon us as the institution's attorneys to go out and to at least involve ourselves with these individuals. And what we do is we try to write letters, we try to bring motions to compel guardians, we try to say, hey, you haven't done your accounting, you got to get it done. Because in those time frames of where it's elapsed for maybe a year or 2 years, assets can be lost. They can be transferred. They can never come back. And the courts are quite reluctant to surcharge guardians, especially family members, people who don't have bonds, people. So always have to mind, why guardianship? Well, hopefully we will have created an uninterrupted stream of resources for the benefit of the ward, of the residents themselves, and ultimately that will benefit our clients. So Mark, how about concluding for us and giving us what your take is? I know our mantra is start strong and end strong, both in this presentation and, of course, in the way we handle guardianships. But how does that really relate to our institutions? What can they do to finish strong in this process?
Well, John, I think you hit the nail on the head. I mean, the idea here is when the decision is made to go down the guardianship path, it's commitment. We have to be committed to going down all the way down the line from the start to finish. And even at the finish line, as we say, the appointment of the guardian, the real work starts at that point to make sure we focus in on helping that guardian do their particular job. One of the things I want to point out is, and many times we encounter situations where we're dealing with powers of attorney. And I want to make sure that you understand that when we're dealing with powers of attorney, most people don't realize that someone may be a power of attorney for somebody, but they don't have a legal obligation to do a thing. It's only when they actually do something that they have an obligation to benefit the individual who they're power of attorney for. So in essence, the power of attorney could wake up one morning and say, I don't want to go to the bank for this resident today. And there's nothing which obligates them or compels them to do so by virtue of being the power of attorney. Same thing with a healthcare proxy. I don't feel like making a medical decision today. They can make that statement. A guardian is different. Once you're appointed as a guardian, you are committed. You are obligated to make those decisions. And if you're not making those decisions, or for some reason decide that next morning I don't feel like doing it today, we can come in and require them to do it. That's the point that John is emphasizing here. We have to make sure that we're dealing. This can be a daunting prospect for some of these individuals that are not familiar with the process, and we're there to kind of help and support them, especially if they don't have the resources and funds to help themselves. So it is very important. I do want to make one other point, John, in concluding, and that is that we have also found, in addition to getting individuals on Medicaid by virtue of the guardianship process, we've also found that we've been able to get the NAMI zeroed out in certain instances when we have are looking to get the fees recovered for the facility. So there, again, we've had good success in that regard. We've had good success in trying to recover assets to help defray the cost of the guardianship proceeding, which is very good to the nursing home and hospital to help offset the cost of these proceedings. And again, I want to emphasize, too, that by getting the person on Medicaid, you've also, as we like to say, stopped the bleeding on a prospective basis, at least until a guardian is appointed and then can file a traditional Medicaid application. I do want to make one other point, and that is that it is not a collection device. It is for the benefit of the individual. I also want to note that we're talking about in August, upcoming August, we're going to be having another session called Survival Strategies for Addressing the Challenges Posed by Medicaid Managed Long-Term Care. And in that session, we're going to have a section on guardianship, dealing with managed long-term care and FIDA plans, and some of the unique things that guardians may have to deal with to protect residents with respect to those plans.
Great. Hey, Mark, thanks for your help today. It has been great working with you on this webinar. As you can see, we've just scratched the surface of this issue, and there's so many issues that are very particular to every individual residents and facilities that I'm sure they have questions about. And we'll hope to answer all your questions if you send us an email, or we can address some of them today if we have time. But again, it's just the starting point. Remember, in your process, always start strong, and then you can end strong.
Thank you, John.